Namaskar and welcome to this program. Today I will talk about a branch of law which is called Law of Torts, and this program is a part of our Diploma in Paralegal Practice program, and this program is offered by School of Law, and this is a 1 year duration program. So if you are interested, you can enroll in this program. In this program, we have covered the basic things about the law. The laws which deal with day-to-day life and the laws which help in developing understanding about the basics of law. So, law of torts is it's a basically it is a civil wrong, and it is as you can see, it's a Latin term, and the definition in Latin it is said twist. Twist means therefore it implies that that twisted or wrongful conduct. That is a wrongful conduct. That is the conduct which is not which is declared or which is considered by the society as wrongful acts, and which are not crime as such. As I told you, this is a civil wrong, and generally the small acts, the acts which can also be considered as crime, but the person against whom the act has been committed has the option to go for civil remedies, or criminal remedies. He can go to the civil court as well as he can lodge FIR and start the criminal proceedings. So in simple terms, as I told you, a tort is a civil wrong for which there is a remedy in action. Actually, in common law system which was prevalent in England, and we have borrowed from the common law system, our because our present legal system was started by Britishers when they came to India. So our system is mainly our legal system is mainly influenced by the common law system. So I will not go into the details or intricacies of the common law system, but in simple terms we can say as far as law of torts is concerned, it is a civil remedy, it is civil wrong for which there is a remedy, and the breach and it is different from a contract. In a contract we have a agreement, and when there is an agreement, the duties of the parties are defined, and also in a contract we specify the damages which the parties are entitled in case of the violation of the contract. But this is not the case with the law of torts, as there is no contract, and the civil wrongs, when there is a violation of rights, or a civil wrong is committed, the remedy is damages like contract, but here the damages are unliquidated, that is not unspecified. So it's not a breach of contract or not a breach of what we say trust. Tortious liabilities arises from a breach of duty towards persons in general, and its breach is redressable by an action for unliquidated damages. So this is a simple definition of a tort. I will explain it later. So there are certain, for example, there injury to rights, and acknowledgement of this injury calculation of the damages, loss sustained, and costs generated in the incident. So these are the certain requirements for the application of the law of contract. So the law of contract is basically in India, it is still uncodified, and so it is not very popular in India, and many of the civil wrongs, which we call torts, have now been incorporated in various legislations, and there is a specific legal provision which deal with those wrongs. For example, accident cases, negligence, etc. In case of accident, it is covered by motor accident, and there are other laws also. So the main difference, because it is also a wrong, civil wrong. So the main difference between criminal law and tort law is that while a civil wrong are committed against the private individuals, criminal offences are perceived as wrong committed against the society as a whole. In simple terms, we can say that when you go for civil remedies, that is remedies under the law of torts, you are entitled to damages, and it is up to you to avail that remedy or not. You can, so if you want that, you should not go to the court of law for availing the remedy. You forgive the person who has committed the wrong. It is up to you. But in criminal law, you don't have the option. If the crime is committed, the criminal is perceived as a threat to the society, as a danger to the society. So you don't have the option whether to go to the criminal, whether to start the criminal proceedings or not. And in criminal cases, the one party is state. You know, when the criminal cases are filed, it is against the state. Or sorry, it is X versus state, state versus X. So state is the necessary party in the, and it is the prosecution side is the state starts the proceeding, state fights the case in the court of law against the accused. So this is the main difference, and essentially the tort law are basically wrongs against the individual. So the main difference is that in a criminal case, the crime is against the society. The state is a necessary party, and you don't have the option whether to start the criminal proceeding or not. But in civil cases, you have the option, and in criminal cases, the remedy is punishment. The punishment can be various types, whether the person can be sent to jail or the person can be imposed fine. But in law of torts, the remedy is always damages. The person who has committed the wrong is liable to pay the damages to the party, and the purpose of the damages is to restore the party to the previous position, as if to the position when the civil wrong was not, when the tort was not committed, as far as money can do. So now the main ingredients of the law of torts, as I told you, is commission of a wrongful act or omission. This is the first thing. In order for a tort to happen, the defendant must do something he was not supposed to do, act or to do something which he is and to do something which he is supposed not to do. So act or omission. So this is the main thing, and another point is a duty. For an act or omission to be liable under tort, there must be a duty to do something or to abstain from doing something that has legal justification. And another point is injury. So I will explain these things. Firstly, there should be a civil wrong. For suppose someone has trespassed on another land, then it is a civil wrong. So if somebody enters another's land without his permission, it is an act which is not permissible. Similarly, if there is a deed, suppose there is a construction activity going on, then it is the duty that if there is a danger to the public, then there should be proper indication to show that some harmful things are there, or there is a hole, there is a pitfall, then it should be properly indicated. Then this is the duty. So if somebody does not do that duty, then it is an act of tort. Similarly, if there is no duties, for example, suppose somebody opens a shop uh, near another shop adjacent to a shop. Suppose A is running a shop and another one, and B opens another shop near to his shop, and thereby his profit is affected. In that case, there is no tortious liability because the person is not under any duty not to open the shop. He has a right to start his business anywhere, uh, wherever he wants. So another point is that injury. Injury means the act or omission must result in an injury that is recognized as actionable. Uh, Even if, so for example, somebody enters another's land without his permission, then it is a injury because it is recognized by law. So, if somebody defames another person, then it is also an injury. Defamation is also one of the. Battery is a tort. Negligence is a tort. If someone does a negligent act, then it is also a tort. So, in injury, even if somebody has not suffered anything, in case of trespass, even if somebody has not suffered anything, in that case also it is actionable because it is prohibited by law. So, there are two conditions, two things which we should take into account. There are two injuria sine daminum. When there is an injury, there is injury, there is a legal remedy. For example, if somebody has trespassed the land, then it is a legal injury or a wrongful act. Therefore, there is a remedy. Similarly, there can be a situation, damnum sine injuria. For example, even if there is a damage, but there is a loss, but there is no injury in terms of law. In the example which I quoted earlier, so if somebody opens a shop near my shop and my profit reduces, I am unable to earn as much as I used to earn before the opening of that shop. Although I have suffered loss, but it is not a loss which is wrongful as per the law. So this is in that case there is no remedy and there is no act of torts. These are the important points which are relevant for our purposes. Now, before coming to some of the exceptions, some of the general defenses which are available under the law of torts, let me tell you that there are certain torts which are recognized in common law systems. Assault is one of the torts. That assault means if somebody threatens to cause physical injury. Battery is as a tort. Battery means somebody hits a person, not very serious injury. I mean, it may not be a criminal, serious kind of act, but somebody hits a person, somebody beats a person. It is a tort. Defamation is also a tort. Now, it is defamation is a civil remedy as well as criminal remedy in criminal law. Negligence is a tort. Malicious prosecution is a tort. And there are other tortious acts also, which is recognized by common law system. Now, if somebody has committed a tortious act, even then there are certain circumstances which permits exemption. If those circumstances exist, then the person is the person can take those defenses and he will be exonerated. He will not be he will not be liable to pay damages. In criminal law also, we know there are certain exceptions which we call general exceptions. It's in the law also, in the law of torts also. The first is voluntary non-fit injuria. If somebody has voluntarily agreed to suffer injury, for example, in a wrestling match, in a wrestling event, wrestling, if some, because you have agreed to participate in the wrestling, and if during wrestling or boxing, if some injury is done to you, if you suffered some injury, physical injury, then you cannot take that defense. It is not a law, it is not a tortious act, because you have voluntarily participated in that activity. The only rider here is that the act should be legal. It should not be an illegal act. In that case, the situation may be different. So there are other also inevitable accident. There may be situations, for example, if somebody has, I mean, suppose there may be a situation where suppose somebody tries to, for example, save a child. In that case, he causes injury to another person, or if somebody is defending himself, or suppose a public officer chasing a criminal, and he fires a shot on the criminal, on the person who is absconding, and in that accidentally another person is injured. In that case, the public official is not liable, because it was an inevitable situation. This measure is also what we call the act of God. Flood, rain, storm like situations. So in those, what we call the act of God, in those situations also, if those situations result in the injury, in that case also the person is not liable. Private defense is also one of the reasons. Suppose there is a threat to the life of a person. In that case, if a person uses some force to save himself, and while saving himself, he causes injury to another person. That is also a defense which he can take. Uh, Mistake of facts is also in sometimes it can be taken as a defense. Necessity is also, suppose uh, in case of uh, for example, if a doctor in order to save the life of a person does perform certain actions, certain surgical operations, in that case a person dies or suffers injury, that is also a general defense which a person can take. Now, there are certain other points which general rules which we have to take into account. Capacity to sue or to be sued, uh, and another is the vicarious liability. Vicarious liability is where suppose a servant causes an injury. In that case, the master is liable because the master has the capacity to pay. Another is the remoteness of damage. Damages is awarded for direct acts, not for indirect acts. For example, if somebody has done some act and due to that another person suffers, or a person suffers the loss which is not directly related to the act, what we call the remoteness of damages, because we have a short of time. So, yeah. So, these are the basic things which I tried to cover with regard to law of torts. So, thank you very much.